Hi, this is Blaine Cluten for Cluten Law. The question today comes around what is evidence in a criminal case. And one of the most misunderstood concepts of evidence is that it has to be something other than testimony, meaning it has to be DNA evidence or it has to be some sort of the smoking gun or the knife that's found at the scene or a video or a recording or something like that. And the purpose of today's video, what I'm going to do is I'm going to read the jury instruction that talks about evidence in the introduction of the jury instructions. And at the end of that, I'm hoping that you'll have a better idea of what is evidence in a criminal case. So here we go as far as what the jury instructions talk about with respect to evidence. Evidence consists of testimony of witnesses and exhibits that are admitted into evidence. Testimony is what witnesses who have sworn or affirmed to answer questions truthfully say while being examined as a witness. Exhibits are physical objects such as photographs, charts, and letters. You will be able to examine admitted exhibits during your deliberations. You may draw reasonable inferences from the evidence, but do not guess or speculate. In understanding what is evidence, it's helpful to have some examples of what is not evidence. The fact that a criminal charge has been filed against the defendant is not evidence. Any defendant is innocent of any crime unless and until the state proves the defendant's guilt beyond a reasonable doubt. Questions from lawyers and other non-witnesses, for that matter, are not evidence. So whenever I, meaning the judge, sustain an objection to a question, do not speculate about why the question was asked or what the answer would have been. This is a subtle but important point. In our everyday lives, if a friend asks us if we have seen a mutual friend's new car, we infer from the question that the mutual friend has a new car. However, it is not the same in a trial. The person asking the question is not a witness and is not subject to the safeguards that the law requires before you may consider the person's words as evidence. So in the court, you're not allowed to consider questions asked by attorneys or non-witnesses in determining what the facts are. Those questions are not evidence. Of course, when a witness answers a question, you may consider the answer in the context of the question. For example, if a lawyer asks, "Was the traffic light red or green?" and the witness answers, "Green," you may take the answer as stating that the traffic light was green. From time to time, a lawyer may object to something that is offered into evidence. I, meaning the judge, will decide whether the objected to material will be admitted into evidence. If the judge overrules the objection, the material, for example an exhibit or a witness's answer to a question, becomes evidence. If I sustain the objection, the exhibit is not admitted and is not evidence, or the witness is not allowed to answer the question. If the witness starts to answer the question before the judge sustains the objection to the question, you must disregard the witness's response because the response is not evidence. Occasionally, the judge may decide that something that has been admitted into evidence should not have been. If that happens, the judge will instruct you to disregard the exhibit or the testimony that should not have been admitted. So this is a brief outline explanation of what is and what is not evidence. As you can see, the examples that are given about what exhibits are as far as photographs and recordings, those types of things are what usually people think of as evidence. But most frequently in a case, what you're going to hear as far as evidence is going to be evidence in the form of testimony. And then the issue is going to be whether that evidence is admitted or not admitted to the court for the jury to consider. This has been Blaine Cluten for Cluten Law.